Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada from the offices of Hull & Hull in Toronto. Here are Ian and Susanna.
Hi, and welcome to Hull & Estates and Succession Planning. You're listening and possibly watching episode 208. Well, welcome back, and again, I'm on a solo mission here because of Susanna's holidays. We are forced to go it alone, but I will endure, and hopefully it'll be an interesting podcast on a solo basis. I wanted to, in the last podcast, I started with an announcement of the reminder to many of us who knew him well, the sad passing of Professor Whiteside from the University of Windsor, Ontario Law School. I also want to talk about, not that this is going to turn into an obituary podcast, but the death of who I think is a really fascinating guy and an interesting book that I just read, and that is George Carlin. Now, George Carlin, known to most of us as a comedian, fascinating guy though beyond that. And he wrote a book. In the last 10 years of his life, he was writing an autobiography. He passed away in 2008, so he didn't actually get to complete it, but he was worked with the co-author in the book, and it's called Last Words. And I just finished reading the book this summer. Fascinating book and a really interesting read because George Carlin was so much more than just a comedian. I mean, he was the guy that branched out into comedy at a level that nobody had seen before in the 70s. He had wild days of lifestyle choices during the 70s and then the 80s, and then he became a children's show expert and became a really interesting philosopher. And if you check out Google, some of the best comments about life, some of the most philosophical comments about life from a modern day philosopher, so to speak, or famous philosopher, are from George Carlin. So anyway, I just wanted to emphasize that I really enjoyed reading his book, and it's called Last Words. And he passed away, as I say, in June of 2008. All right, before we were talking about interpreting wills. And again, I think it's important to me because I thought it would be a helpful analysis to consider when one does a will, what can happen? We've talked about how it can go astray because family fights. We can talk about solicitor's negligence where you draw the wrong word, you put the wrong words in. What we haven't talked about a lot is what happens when the words aren't clear. And I talked about my last podcast, the matrix, the steps that the court will take in coming to its understanding and ultimately its decision as to what the words mean. And where I'd left off was I had walked through the fact that we read the will as a whole. I walked through that if we can get a plain meaning out of the words, we stop there and we finish the analysis. If we can't, there's still some ambiguity in the language of the will. Then we go to the next level, and that is look at the surrounding circumstances of the factual matrix. And I just wanted to spend a few minutes digging down a little bit on what we mean by how deep we can go. Because it's often said that it would be helpful to, obviously it'd be great if you're trying to interpret a will if the person who drew the will was around. Well, they're dead, so we can't use them. And so a lot of people think intuitively, well, let's go talk to the lawyers or the doctors or the people that were around, around the deceased when this was all happening. And there's layers of admissibility. There's a whole bunch of rules of evidence that come to play in that regard. But what was important, and it's really interesting the way the courts have approached it, is that they've said, look, we're going to look to what is really easily identifiable evidence. And when I say that, I mean documents, letters, codified notes, things like that were created contemporaneously at the time the trust was made, at the time that the will was made. They're going to also, and in rare occasion, they're going to listen to and, in a sense, enhance their knowledge of the surrounding circumstances. And remember, I talked about the armchair rule. Get a real feel of the deceased's thinking by sitting in the big chair and thinking it through. By looking at, on rare occasion, and at sort of the lowest level of evidentiary admissibility is the idea of talking to the lawyer themselves if they're still alive, getting their direct evidence today. So putting to that lawyer saying, well, what did the testator mean when they said this? And do that by way of examinations in respect of the lawyer. Now that's an option as well. And really what the courts have said is we discourage that a little bit. We'd rather source it from the concurrently made documents at the time that the will or the deed was being drafted. That's sort of position A if we're going to look at the surrounding circumstances or we're going to look at the factual matrix. So that food chain of review and that sort of, again, it's an interpretation matrix. We talk about a factual matrix. That's the interpretation matrix that the courts will typically step into when sitting down and being asked to answer what the specific words in a will or a trust mean. So in the context of that, of course, are situations where you want to say, okay, well, if we have an interpretation that needs to be undertaken here, what's the process? And I'll just tell you briefly what the process in Ontario is, and it's similar across Canada and mostly in the United States where interpretations are necessary, is that you go to the court. When I say you, typically the estate trustee reads the will and says, I don't know what that means. It's ambiguous. I'm not sure what steps to take from an administration standpoint. Do I pay it to A? Do I pay it to B? I'm not sure. It's not clear. You bring an application for advice and direction. You go to the court and you say to the court, look, this is what it says. This is what it could mean. This is what it also could mean. We need you to help us interpret this. And when you set up this system, it's typically three parties. The one party, the neutral trustee that says, look, I can't understand these words. It could mean this. It could mean that. And then what happens is this and that get lawyered up. This and that get represented. So if the trustee says, well, it could be that I pay all my money to A, but it could be I pay all the money to B, A gets a lawyer to advocate strongly that it comes to A, and B gets a lawyer to advocate strongly that it comes to B. So you can see how the litigation matrix unfolds. And that is that a neutral proposition is put to the court, and then it's worked out and analyzed and argued in respect of either side, with the benefit of having the court have at least started the process with an analysis that's sort of neutral. And it's sort of like, well, look, these are all the possibilities, Your Honor. Now, you'll hear from all of the others as to what they think is the right one. I'm not saying that the right one is, Your Honor. I'm just a neutral trustee, but I want you to understand the issues before they step into the clock and start pumping up those arguments. So that's the process. I've involved with money over the years, and fascinating legal arguments, and involved in legal analysis, statutory interpretation, and those kinds of But anyway, those are my thoughts on interpretation and the interpretation process. I hope it's been helpful. Again, reminding everyone to feel free to take a look at George Carlin's book, Last Words, Last Words, sorry, not about Last Words. Great from the leadership of the summer. Thank you for joining us.
You have been listening to Hall on Estate and Succession Planning by Ian Hall and Susanna Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hall & Hall podcasts or leave any questions or comments, please visit our website at hallestatemediation.com.